If you would announce yourself for the record, tell me who you represent and whether you're moving or respondent in today's hearing.
Your Honor, Belinda Arambula on behalf of Brian Fraun. And in part, we are movement. We have a plea to the jurisdiction that's been filed with the court that I believe will dispose of all issues in this case. And beyond that, we are responding to what appears to be either a motion for temporary restraining order / a TI, I'm not quite sure, a motion to strike our general denial answer and affirmative defenses. And I think that includes the hearing.
All right. Ms. Gallagher, we can't hear you.
Good morning.
Good morning. Ms. Gallagher, you in some message to the court asked or said that English wasn't your first language. Is that correct?
Yes, my first language is French, so I put some notes to the court inside the box.
Yeah, my question is, were you requesting to have an interpreter?
No, I can understand, but I can't understand if it's too complicated, like the juridic words. Some words I can understand, but otherwise I can.
That's why I'm asking, are you requesting an interpreter or not?
No, I can't. I really need this.
We're not going to give you cards. Cards is not going to happen. So the question is, are you looking to have somebody interpret for you to give you an understanding of the words that are coming from the court or that are happening in the hearing? You keep saying no, and I'm happy to move forward, but it does seem that what you're asking for is someone to interpret for you certain words.
No, it's okay. I need to stay. I want to stay.
I'm sorry?
It's okay. I can and I can. I want to stay. I can understand.
Well, I've looked at what we have in front of us. Interested in hearing. You've filed a motion to strike the plea to jurisdiction, and so the plea to jurisdiction and the motion to strike the plea to jurisdiction is what I think we need to hear first. At the end of that hearing, I can then figure out whether or not we need to move forward, if we need to move forward in a different way, or how we need to move forward is more precisely the case. And so I'm going to ask Ms. Arambula.
That's perfect, Judge.
It's go ahead and start on her her motion, and then you can talk about your motion and what you're trying to do in terms of striking. I ask you, if you at some point feel like you need to have an interpreter, just let me know. But
Thank you so much.
but I don't want to be in the middle of this. So that's why I'm going to ask you one more time. You keep telling me no, and that's fine. But if you don't, then I'm just going to go forward with her motion, which seems to be the best way to start here today. Okay?
Thank you.
All right. Yes, ma'am. Go right ahead.
Thank you, Your Honor. May I share my screen?
Yes.
Thank you, sir. Your Honor, we're here today on a lawsuit brought by Ms. Gallagher against my client, Brian Fraun. As you'll see from the summary here that I'll present to you today, I am moving the court to dismiss this case based on jurisdiction. I don't believe that the county court at law has jurisdiction for a couple of reasons, primarily because the plaintiff has sought damages totaling $8 million. She has also filed for possession of property, which necessarily is dictated to the JP court, who has exclusive jurisdiction over that issue. And then to the extent we get into any kind of injunctive relief, I believe that the petitioner is seeking relief that cannot be awarded by the court because it's either unclear as to what the relief is, it's truly just monetary, or it actually concerns non-parties who are not before the court, such as the landlord. I'll walk you through a little bit of the history here. The petitioner and my client were former roommates. They had signed a lease for a property in the Wells Branch area that began in November of 2024. They discontinued living together in April of 2025 when the petitioner asked my client to move out of his home, and he conceded. At that time, Mr. Fraun continued to pay under the lease. That is good. The lease does not expire until April of 2026. Mr. Fraun has continued to make all payments under the lease. He also continued to pay all utilities. By April 1st of 2025, when he moved out, he gave Ms. Gallagher notice that the utilities would need to be transferred to her name in approximately 3 months. Throughout that 3-month period, he continued to pay. She never requested the transfer, and the utilities eventually came off in July of 2025. However, that's just background. The primary issues that we're here today are on the plea to the jurisdiction. Plaintiff has asked for the court to transfer her case to the district court because of the $8 million relief requested. She's also requested that the court strike our answer and requested either the TRO or the TI. With respect to the plea to the jurisdiction, Your Honor, I'm asking the court to recognize that the JP has exclusive jurisdiction to determine the right of possession of the property. Mr. Fraun is not in possession. He has relinquished possession as of April. Ms. Gallagher has exclusive possession of the property, but if that was truly the issue, I believe it needs to be litigated before the JP. Again, to the extent she's requested $8 million in monetary damages, that exceeds your jurisdictional limit under the government code, which limits the court's jurisdiction to $250,000. With respect to the injunctive relief, if we get there, on the monetary issues, what I totaled, it looks like she's requesting about $270,000 today. In addition to that, she's requesting ongoing monthly payments that would certainly continue to accrue well beyond the obvious $250,000.
Okay.
Sorry, it's freezing on me. Your Honor, we briefed this. We filed our response on Friday. I'm relying on the Barch Institute LP versus Title Max case to explain and to support our position that the JP has exclusive jurisdiction to determine possession. I don't think that's really a disputed point for the court. That they're well aware that when we're dealing with issues of possession, that is primarily an issue that resides before the JP. Additionally, that's generally an issue between a tenant and a landlord. The landlord is not before the court. Where I get the $8 million, Your Honor, just for the court, for transparency for the court, the plaintiff filed a motion to transfer the case to district court. In there, she pled that she's exceeding damages of $8 million to support our request that this case be dismissed as it's beyond the court's jurisdiction. Other areas in her various pleadings allege different damage amounts. These are the damages that I've seen. I tried to show to the court in her Exhibit J. She's pled $2 million for certain relief, another 1.5 for a different type of relief, but she references to her main complaint. She also requested $2.5 million for yet another form of relief, and then an additional 1.3. This all demonstrates to the court that she clearly is seeking monetary relief well over the court's jurisdictional limit. Wanted to give the court a little bit of additional guidance as to the background on this case. Petitioner previously filed a request for a TRO. Judge Wong considered that and appropriately denied the request back in July 8th, 2025. The conditions between the parties have not changed. Ms. Gallagher still has the keys to the house. She still has exclusive possession of the house. I'm not sure where she's staying, and I would submit to the court that she's probably not in the house, though it's available to her because she's asked the court to award her transportation fees, hotel expenses when she comes to Travis County. So I don't believe this is an emergency situation anymore. Your Honor, I think I'll stop right here before we get into the merits of the TI, because I think what I've discussed so far addresses the plea to the jurisdiction. And I can follow up should the court have any questions or allow me to go into the merits of the TI.
All right, Ms. Delphine, Ms. Gallagher.
Yes, sir. No, Your Honor.
I'm sorry, would you like to respond to what Ms.
Yes,
Aramoglu?
of course. So, first in all, thank you for hearing me today. I appear in pro se, first in all. I defend my plea is not based on law, but on a tactic of delay in coercion. I just give you some notes in the box. If you can just see this, it can be more easy for me to explain myself and to have the chance to have the same.
Well, just tell me what it is you're trying to do, ma'am.
Okay. So when I feel the jurisdiction, when I feel I good in a good faith, I believe the court could hear me by emergency request, and I see when I apply is not about the damage, but I think it's about the tiero ou the ex parte, and I do not need exceed 215 is what's the limit.
I'm sorry, what you said, what was the limit? Ma'am, you saw
Sorry, I think 215 is the limit when you have in the tiero and when you have an ex parte, because I ask an ex parte because of emergency. 2 times Mr. Franz tried to make me an evictions. I have one tentative to evictions the 10 May, a 3 days notice. And the 7 July, I have another one. And it's for that I'm here. He's tried to sabotage my entreprise. He's make a constructive evictions and I lose stable housing. Illegal utility and shut off. This is absolutely true. But before he's let me in home, infested in flea. I working for him to January and March, and he doesn't pay me, and he's let me in. Sorry. I'm very sorry. So the 24, I relocate to Austin under a respondent promise of support. And it was, I was abandoned in house, and the house was in March and April infested with flea, with cockroaches and contaminations. In April 2, I need to go first in medical. I have the prescriptions. If you can see the exhibit A. In April 2 and 3, the first wave seizure, I working for Mr. Fron, and he's need to pay 2,500. He didn't, and he's blocked me for paying the urgent bills. In April 3, I have the second wave seizure in exhibit D2, if you can see in box. I put all my exhibit. And last 24 hours later, instead to pay me, he was threatening me for an evictions. In April 21, I begin the respondent for assistance due to burden, lesions, and exhaustions because I do not have the money. It's take off me all my money. He's need to pay me for the working I give to him for 2 renovations to home.
Okay.
If you can see the exhibit C2.
Ma'am, I can't see the exhibits while you're doing the hearing. The exhibits are in box and we can look at them at a different time. I just wanted you to tell me what.
Oh, I'm sorry. I think we can see the exhibit in same times.
That's why I said, just tell me what it is you're saying.
What I say, it's not happen like he's give me 2 months for pay the utility bills or otherwise. He's let me in home completely infested and I can't pay because I working for him to January in March, and every time he's need to pay me and he's blocked me this payment. After he's tried to go in coercion with the landlord and is make me a 3 days notice, the 10 May. This was the first tentative to evictions. After the 13 June, he's shut off electricity, gas, everything, and it's not true. It don't give me a 2 months notice. He's tried to evict me first. After he's do that, he's shut off the electricity, the gas, and all. And after he strives to say, okay, I don't pay right now this month, but he's don't pay me before for what's working, I do it for him. So it's not in this moment, I can't pay this rent. And he's do that in purpose, little bit, he's blocked me in this bulk precarity, if you prefer. And he's blocked me the fact I can working. He's blocked me the fact he's strive to block me for I can't pay, I can't do nothing, I can't working. It is do all. I know you can see right now all proof, and I'm sorry, I think you can see the proof, and sometimes I speak, so.
Okay, ma'am.
Maybe I do that, but I'm really sorry, Your Honor. I hope I have the chance to explain myself, and I hope I can have the same right to somebody who don't have the lawyer.
All right. Ms.
Right now,
Arambula, is there some reason we can't just transfer this if that's the request? That's what I decide?
Right, Your Honor. No, I don't think you can transfer this because she is seeking possession, as what I understand from her various pleadings. She's seeking possession of a property that she has possession of, and under Chapter 92 and Chapter, I think it's 92 of the Property Code, this should be before the JP to the extent she's seeking possession of this property. Also, I've got to remind the court that much of the relief she's requested in her pleadings relates to the landlord. Mr. Frond was not a landlord of this property. He is a co-tenant who she kicked out in April of 2025, and he has continued to pay rent without interruption despite not living there. And he actually amicably offered to continue to pay the rent through the remainder of the lease period. She did not accept that. So right now, nobody's in the property. She's not there. She has the keys. She has exclusive possession, but she's fighting about this possession. So I think it needs to go to the JP, if anything. To the extent she's potentially arguing other issues, I still think, Your Honor, that it's not proper. She hasn't pled any cause of action that actually exists in the Texas law. I have, and I can show you, her complaint lists 3 primary causes of action, none of which are actionable in Texas. Count 1, she listed as willful cruelty toward a vulnerable person. Count 2 was malice, intentionally and continuous malevolence. And count 3 was vital service shut off during extreme heat. These are not recognized causes of action in Texas. So I'd ask the court grant our plea to the jurisdiction on this basis.
All right, let me take it under advisement before we move forward, see where we are. I'll get it out to you probably pretty quickly, or maybe even today, probably no later than tomorrow, about the ruling, and then we'll see where we are at that point, and then go forward from there. All right?
Thank you, Your Honor. I appreciate it.
All right, thank you.